defendant was originally charged with manslaughter. That charge was upgraded by me when I was given the case to handle to murder. However, because of all the press coverage we had, Mr. Newman made a request, which I did not object to file a murder indictment under seal. Because the manslaughter indictment was not under seal and it was already out there, had been publicized, I felt like it would have created a lot more, frankly, media drama had I had null pros the voluntary manslaughter, and then everybody would have been calling, wondering where this charge went because it was dismissed, not knowing that there was a murder indictment already filed. I agree with him. We need to elect. We're going forward on the murder, so I will go ahead and dismiss the separate voluntary manslaughter petition, which is 2011 GS 7-0120. The state will be electing to proceed on the murder indictment, Your Honor, 2014 GS 07-359. Again, that one was filed through another circuit court judge, Your Honor, through our resident judge. That one was filed under seal at Mr. Newman's request, but I will dismiss that on the record and I will hand it up to the clerk's office.
Would you throw out a case that on a directed verdict, if you heard evidence that a man walked up with a gun and took property from another person and then was shot to death, and on the accomplice, would you direct a verdict because you say, well, you can't prove that there's no intent to permanently deprive? We don't know what their intent was. Someone sticks a gun in your face in the man's property. I think the intent can be certainly inferred. The property was never returned to the Rhodes.
Maybe I have misinterpreted the briefs submitted by both sides. I thought that the evidence was going to show that the deceased wanted the keys for the purpose of unlocking.
Right, and they couldn't figure out how to do that, so they ordered the defendant out of the car to do it himself, and that's when the shooting occurred. Now, you also have the crime of kidnapping. He was ordered out of his vehicle to go take that off, and I do have case law I can bring you that you can't have armed robbery and kidnapping existing at the same time. You also have the crime of carjacking since he was ordered out of the car. So there's plenty of felonies out here to talk about. But I think that would be an evidentiary finding. We don't know what the intent is, what they were going to do with that keys. They didn't take the boot off the car. So I don't know what their intent was. Ultimately, I think that he came out with the gun and demanded that his car be released. I get that. But if you still take something from somebody at gunpoint, this kind of disingenuous to come up with, well, we don't know if he intended to permanently drive. That's a factual question. But the question out there is whether or not a robbery occurred, whether or not a kidnapping occurred, whether or not a carjacking occurred, whether or not a pointing and presenting a firearm occurred, and multiple felonies.